Hey legal studs. In this video, I'll take you through a few tips to help you save time and maximize your marks for legal studies. Tip 1. Use study strategies and memory techniques. Find out what combination of strategies and techniques works for you. I mostly used summary notes and cue cards to study the content and practice questions and exams to test my application ability. Another approach you could use is the traffic light method. For this, write down all the topics you need to know for your SAC or exam. From there, go through each topic, highlight or underline what you don't know in red, what you sort of know in yellow, and what you know well in green. From there, you should study every topic you identified as red, then every topic you've identified as yellow until all your topics are green. Memory techniques refer to the specific methods you use to memorize specific content. You could use mnemonic devices. For example, when you're learning about flexibility of the doctrine of precedent, learn ROD for reversing, overruling, distinguishing, disapproving. If you're memorizing the role in the Senate, learn Irene runs slowly, or IRS, where I stands for initiates legislation, R stands for review, as in House of Review, and S stands for States House. Tip 2. Know key terminology. If you know your key terminology, not only are you showing the examiner that you know and understand the content, but you can also express yourself in a more succinct way. Knowing Latin terms like orbiter dictum, for example, will really enhance your work. Tip 3. Know key facts. Know small key bits of information. Sometimes you'll find yourself losing out on a mark because you've forgotten to include one or two specific words. To avoid this, make sure you memorize carefully worded definitions and very specific bits of trivia. For example, know that to get full marks on a definition of petitions, you need to be able to mention that they're tabled in Parliament. Also, make sure that you memorize the numbers of specific sections within the Constitution. For instance, know that the right to trial by jury for indictable Commonwealth offences is contained in Section 80. Take a look through old examiners' reports to see what key bits of information students have struggled with in the past to make sure you don't make the same mistakes. Tip 4. Know key verbs. Know that evaluate and analyse require you to look at both the strengths and the weaknesses of a legal institution, whereas explain asks you to describe something in detail. Justify, meanwhile, asks you to back up your argument. Something you should do in your own time is make a list of all the verbs you notice coming up in the questions you get. Then write out what you need to do in response to each of those verbs. Tip 5. Examples. Use examples often. Even if the question doesn't ask you to use examples, using them can help you explain your point and round out your answer. Try to use contemporary examples. In other words, examples of things that have happened in the last 5 years. As an example of a demonstration, you could mention the protests against the forced closure of Aboriginal communities that have been held this year in Melbourne's CBD. Tip 6. Try to link longer answers back to principles of the legal system. For example, if you're evaluating the court hierarchy or evaluating the jury system, keep in mind things like the entitlement to a fair and unbiased trial, accessibility of the legal system, and timely resolution of disputes. If you have those principles in the back of your mind while answering complex questions, you'll do a better job of getting to the why behind our legal system. Tip 7. When you're asked to evaluate or analyse, try to find weaknesses and strengths that correspond to each other. Rather than just listing strengths and weaknesses, find the links between them. This will make your answer more sophisticated and will give you a better chance at writing a strong overall answer. For instance, if you're asked to critically evaluate courts as lawmakers, you could mention that, as a strength, judges are unelected. This means they don't fear voter backlash on controversial issues and can make law when parliaments are unwilling. However, a corresponding weakness would be that, because they're appointed rather than elected, judges might make decisions that don't reflect the values of society. Tip 8. Practice bigger, globally marked questions. Global marking refers to questions worth about 5 marks and above. It means that your answer is marked as a whole, as an overall piece. In a 2-mark question, you might be awarded 1 mark for a definition and 1 mark for an explanation. It doesn't work like that with the larger questions. One key point does not necessarily correspond to 1 key mark. So, focus on your overall response rather than worrying about how many points you've made. It's about quality. That being said, it's really difficult to form a coherent structure when you're answering longer, globally marked questions. That's why I'd advise that you have one sentence or paragraph for your introduction, followed by one paragraph for each argument or key point that you're trying to make, and one sentence or paragraph to conclude. The only way you can get good at these longer questions is by doing practice questions. Using these helped us succeed at legal studies. We're sure that they can do the same for you. Thanks for watching and happy studying.